Let's take a look at the history of employment law. No single set of employment laws covers all workers in the United States. Whether and how laws apply depend on such things as whether the employee work for the government or in the private sector, whether they have union representation, and the size of their employer. Our main focus will be on federal laws because these reach most widely across U.S. workplaces and often serve as models for state and local law. We will also mention significant variations in employment laws of different states. There's another problem with the idea of just learning the legal rules and adhering to them. Employment law is dynamic. New law is created and old law is reinterpreted continuously. Recent political changes and the prospect of significant realignment of the U.S. Supreme Court create uncertainty about what law will change. At any point in time, there are well-settled legal questions on which there is consensus, other matters that are only partially, and still other questions that have yet to be considered by the courts and other legal decision makers. Attaining a solid grasp of employment law principles will allow you to make informed judgments in most situations. You must be prepared to tolerate some ambiguity and keep learning, however, as the law of the workplace continues to develop. Legal rules governing the workplace are issued by all branches of national and state government. Constitutions are the most basic source of law. Constitutions address the relationships between different levels of government and between governments and their citizens. A legal claim based on a constitution must generally assert a violation of someone's constitutional rights by the government. In practical terms, this means that usually only employees of government agencies and not employees of private corporations can look to the U.S. Constitution or state constitutions for protection in the workplace. Constitutional protections available to government employees include speech rights, freedom of religion, protection of unreasonable searches and seizures, equal protection under the law, and due process rights. In our system of government, voters elect representatives to legislative bodies such as the U.S. Congress. These bodies enact laws or statutes, many of which affect the workplace. Among the many important statutes with implications for human resource practice are Title VII of the Civil Rights Act, the National Labor Relations Act, and the Americans with Disabilities Act, as well as the Family Medical Leave Act. The executive branch of government has the power to issue executive orders that affect the employment practices of government agencies and companies that have contracts to provide goods and services to the government. Executive orders function much like statutes, although they reach fewer workplaces and can be overridden by the legislative branch. One important example of an executive order affecting employment is Executive Order or EO 11246, which establishes affirmative action requirements for companies that do business with the federal government. Formal regulations are put in place only after an elaborate set of requirements for public comment and review has been followed. Regulations are entitled to considerable deference from the courts. Generally, they will be upheld when challenged, provided that the regulations are viewed as reasonable interpretations of the statutes on which they're based. Agencies also contribute to the law through their decisions in individual cases that are brought before them and the guidance that they provide in complying the laws. Courts are sometimes asked to resolve disputes over matters that have not been objects of legislation or regulation. Over time, courts have recognized common law claims to enforce private agreements and to remedy certain types of harm. Common law is defined by state courts, but broad similarities exist across states. One branch of common law is the traditional role of the courts in interpreting and enforcing contracts. The other branch is recognition of various tort claims to compensate persons who have been harmed. Tort claims relevant to employment law include negligence, defamation, invasion of privacy, and wrongful discharge in violation of public policy. Paradoxically, the starting point for understanding employee rights is a legal doctrine holding that employees do not have any right to be employed or to retain their employment. Employment at will holds that in the absence of a contract, the employment relationship can be severed at any time and for any reason not specifically prohibited by law. Though statutory and other rights have significantly blunted the force of employment at will, it remains the default rule that permits employers to terminate employment without needing to have good reasons for doing so. Broadly speaking, employees have the following rights under employment law. A central part of employment law is the set of protections for employees against discrimination based on their race, sex, age, and other grounds. Title VII of the Civil Rights Act of 1964, the Equal Pay Act, and the Americans with Disabilities Act are examples of federal laws that prohibit discrimination in employment and express the societal value of equal employment opportunity. Labor laws exist to protect the rights of employees to join together to form labor unions and attempt to improve their terms and conditions of employment through collective bargaining with their employer. Important federal labor laws include the National Labor Relations Act, the Railway Labor Act, and the Civil Service Reform Act covering collective bargaining by federal government employees. Some employment laws protect workers in a more direct fashion by specifying minimum standards of pay, safety, and other aspects of employment. Federal laws exemplifying this approach include the Fair Labor Standards Act, the Occupational Safety and Health Act, and the Family and Medical Leave Act. A variety of privacy-related protections exist, including privacy torts, the Electronic Communications Privacy Act, and the Employee Polygraph Protection Act, as well as the Fair Credit Reporting Act. Employees can take legal action to recover damages when, for example, they're victims of employer negligence, are defamed, or are wrongfully discharged. There are a few key contextual factors that determine which, if any, employment laws apply in a given situation. The legal environment differs substantially depending on whether public sector, government employees, or private sector employees are being considered. The terms public sector and private sector do not refer to whether a company trades its stock on the stock market, but rather to whether the employer is a government agency or a corporation. Beyond constitutional protections which pertain only to public employees, there are often covered by state or municipal civil service laws, collective bargaining agreements, and tenure provisions. However, public employees are also subject to restrictions on their political activities, excluded from coverage under the NLRA and OSHA, and limited in their ability to sue for violations of federal law. In contrast to the vast majority of employees who lack employment contracts, unionized employees have many of the terms and conditions of their employment spelled out in enforceable labor agreements. Employers in unionized workplaces are also more limited in their ability to make unilateral changes in workplace practices without first negotiating these changes with unions. Discipline or discharge of a unionized employee is contractually limited to situations where the employer can establish just cause for the discipline or discharge. For purposes of some statutes, including the Fair Labor Standards Act and the National Labor Relations Act, size is measured in financial terms and coverage is limited to employers that exceed a minimum level of revenue. More often, statutes specify a minimum number of employees. For instance, both Title VII of the Civil Rights Act and the Americans with Disabilities Act limit coverage to companies that have 15 or more employees. These size limitations are not trivial. Almost 90% of firms in the United States had fewer than 20 employees in 2014, which means that the vast majority remain outside the reach of federal employment law. An employee's rights are affected by where he or she happens to live. Some states and cities go much further than others, and also further than the federal government in conferring rights to workers. The interrelationship between federal and state law is a complex legal matter. At the risk of oversimplification, states are usually free to enact laws pertaining to issues not addressed by federal law. State laws can, and often do, match or exceed the protections available under federal laws dealing with the same matters, but they cannot reduce the rights that employees have under federal law. Governments sometimes use the contracting process to leverage to get employers to implement desired workplace practices. For example, employers that contract to do business with the federal government and meet other certain criteria are required to engage in affirmative action as a condition of their contract. Most employment laws apply to any industry, but some are more narrowly targeted. At the turn of the 20th century, employment law was virtually non existent in the United States. The first significant departure from the unregulated workplace was the adoption of state workers' compensation laws to deal with the severe problem of injured workers. A major breakthrough came in the 1930s when the National Labor Relations Act and the Fair Labor Standards Act were enacted. Employment law took large strides forward in the 1960s with the passage of major anti-discrimination statutes, including Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, and the Equal Pay Act. Common law claims, particularly for wrongful discharge, came into vogue in the late 1970s and throughout the 1980s. Benefits have been the target of a number of employment laws since the 1970s, with health insurance, pensions, and leaves being at the center of recent legislative effort. Legislation does not emerge in a vacuum. Many of our employment laws reflect the work of social movements, organized efforts to create needed changes in workplace and society. The workers' compensation statutes adopted in the early part of the 20th century were influenced by the progressive movement, which addressed the social problems of the time. The National Labor Relations Act was enacted in 1935 during the depths of the Depression. The act furthered the efforts of ordinary workers, joined together in the labor movement to gain some control in their work lives. The civil rights movement had to overcome enormous opposition to obtain legislation protecting the basic civil rights of all people, and the struggle to realize this law's promise continues. Our employment laws are windows into important periods in our history, express basic societal values, and represent hard-won accomplishments that should not be taken for granted. Though the workplace is far more regulated than it once was, U.S. employers still have far more latitude in human resource decisions than in many other industrialized nations. Simply granting rights on employees is not enough. Means of enforcing those rights must be available when employers do not live up to their legal responsibility. The process of resolving employment disputes is anything but simple or quick. A wide variety of enforcement procedures exist for bringing and resolving claims related to violation of employment law. The applicable procedure depends on the particular law that forms the basis for the claim. However, it's possible to convey some of the more typical ways in which employment law claims proceed. In a few situations, employment laws are enforced by government agencies at their own initiative, such as when OSHA elects to inspect a workplace based on an occurrence of a serious accident. However, as a general rule, both the courts and government agencies rely on employees to come forward with complaints before enforcement actions are undertaken. Thus, the decision of an employee to challenge some action of their employer is a key part of the enforcement process. Although there are undoubtedly some frivolous claims brought against employers, it's a mistake to assume that most employee complaints are baseless and rooted in opportunism. Contesting one's employer in the legal system is an expensive, protracted, uncertain, and emotionally draining process. Most likely, the cases that are brought up are just the tip of the iceberg. Most employees who have their rights violated by their employers do something other than take legal action. They quit, join a union, withhold discretionary effort, just let it go, or talk it over with the employer and work things out. Ultimately, our system of employment law depends on employees being willing to come forward and assume the burden of taking legal action. An important feature of any enforcement procedure is the length of time that an aggrieved person has to come forward with a complaint. This is the limitations period. Time limits for filing lawsuits or charges with administrative agencies vary. Unfair labor practice charges must be brought to the National Labor Relations Board within 6 months of their occurrence. In discrimination cases, employees generally have 300 days to file a charge with the Equal Employment Opportunity Commission, but only 90 days to file suit if the EEOC's efforts to resolve the case conclude unsuccessfully. This means employers must be prepared to defend actions taken well in the past by individuals who might no longer work for them. The only way to do this is to maintain solid documentation regarding all human resource decisions. Employees who fail to bring charges in a timely fashion generally lose their right to pursue legal action. The clock usually starts ticking when the employee receives notice of a decision rather than on the effective date of that decision. This is known as equitable tolling. This doctrine is applied sparingly and generally does not shield employees from the consequences of negligent legal representation. When applying limitations periods to discrimination cases, courts distinguish between discrete acts, such as nonhiring and termination, that occur at particular points in time, and acts that recur and have a cumulative impact. Repeated acts of harassment that over time create a hostile work environment are a prime example of the latter. Employees who claim that they have been subjected to a hostile work environment can challenge all of the harassing acts, even if those go well beyond the limitations period, provided that at least one incident of harassment occurred during that period. Sometimes, employees claim that harassment or other discriminatory treatment leaves them with no option but to resign. An employee who quits under these circumstances is sometimes found to have been constructively discharged. The Supreme Court has said that the limitations period in such cases begins when the employee gives notice of her resignation, rather than on the date of the last discriminatory act that prompted the employee to quit. What about pay discrimination in this light? Is it a discrete act in which a decision is made at a particular point in time to pay an employee a discriminatory low amount? Or is it an ongoing violation that recurs with each paycheck? Congress enacted the Lilly-Ledbetter Fair Pay Act, which established that each low paycheck is a separate violation that starts the limitation period anew. Most employment laws enable employees to enforce their rights through lawsuits against their employers. As an exception, if an employee reports a safety hazard to OSHA and the inspector does not agree that there is a problem and the employer is not cited, no course of legal action is available to the employee. Likewise, if the appropriate officials of the National Labor Relations Board decline to bring a complaint regarding an alleged unfair labor practice, the employee is out of luck. Suits in discrimination cases can be brought by individuals or the EEOC. But because only a very small percentage of cases it receives go to court, the burden of taking legal action falls mainly on individual employees. Employment lawyers accept only an estimated 5% of employment discrimination cases brought to them. Lower wage workers, for whom provable damages are relatively low, are particularly likely to have their cases turned away. Considerable managerial time is spent when a lawsuit's filed, responding to requests for records, answering interrogations, and giving sworn depositions regarding the facts of a case. The best advice is to answer questions truthfully and succinctly and to have documentation to back you up. Settlement negotiations are likely, both at this point and throughout the course of litigation. Employment law cases are brought in both state and federal courts. Where the case will end up depends on factors like the legal basis for the claim or where the parties reside or are incorporated. A case that goes into the federal court system starts at the district court or trial court level. The role of the district court is to establish the facts of the case and reach a decision about employees' claims. However, many cases filed against employers are dismissed without a trial because the court determines that even if the allegations are true, they're not sufficient to support a legal claim. If a case does go to trial, the plaintiff bears the burden of proof to show, generally by a majority of the evidence, that his rights were violated. Cases that go to trial are sometimes decided by juries and other times by judges. District court decisions can be appealed by either party to a federal appeals court known as a circuit court. Appeals courts typically accept the facts of cases as given and focus on whether the lower courts properly applied the law in deciding cases. Appeals courts' decisions can be appealed to the U.S. Supreme Court. However, because the Supreme Court exercises its own discretion as to which cases it hears, and it hears relatively few cases each year, rarely does a case go that far. Judges enjoy considerable latitude in deciding cases. While courts sometimes change their minds about the law, they have a strong preference for adhering to prior decisions known as precedents, or at least giving the appearance of doing so. This desire for consistency and stability in the law is captured by a phrase which means, let the decision stand. Most lawsuits are brought by one or perhaps a few named plaintiffs on behalf of themselves. In class action lawsuits, plaintiffs sue on behalf of themselves and some larger group of persons. They claim that their rights and those of other class members were violated in essentially the same manner by the defendant. Individuals can opt in or out of class action lawsuits, and any award is shared by the class member. Class action lawsuits are controversial. Plaintiffs' counsels see them as an efficient means for pursuing the claims of many individuals who might not otherwise be able to take legal action. Corporate defendants tend to see them as collections of disparate allegations strung together by attorneys seeking to maximize their earnings. The class action lawsuit is a potent weapon for plaintiffs. The prospect of facing a team of lawyers seeking substantial damages on behalf of a large group is obviously a great concern to an employer, so there's strong incentives to settle. A key initial determinant that must be made in these cases is whether multiple persons have claims that are sufficiently similar to justify their certification as a class. Plaintiffs have encountered difficulty advancing class-based discrimination lawsuits. They have a much better chance of achieving class certification if they involve smaller numbers of employees employed by the same establishment. While class action lawsuits are still being brought in significant numbers, the ability of employees to challenge the policies and practices of large corporations has been diminished. Some employment laws require that a charge be filed with an administrative agency and that agency be given the chance to resolve the matter before an employee can go to court. In discrimination cases, an employee usually starts by filing a charge with either the EEOC or a state fair employment practice agency. The EEOC takes a number of steps in regard to the cases it receives. If the EEOC finds that discrimination likely occurred, it's not empowered to fine employers or require that they remedy their discrimination. Instead, the agency undertakes a conciliation process in which it becomes a party to settlement negotiations with the employer. The EEOC has considerable discretion in how it goes about deciding whether to accept a settlement offer. It has a statutory duty to conciliate, which requires at a minimum that it inform employers of its finding of discrimination, offer to conciliate, and give the employer the opportunity to remedy the alleged discriminatory practice. If the EEOC dismisses a case or fails to achieve conciliation between the parties, it issues a right to sue letter to the employee alleging discrimination. Only then is the employee able to commence a lawsuit. Other types of legal claims, such as breach of contract or negligence, can be proceeded directly to court. If an employer has a complaint or grievance procedure, the employee does not usually have to use the internal procedure before taking the case to an enforcement agency or to court. However, this is an area of the law where profound changes are occurring. The Supreme Court has held that an employer may be able to escape liability for harassment engaged in by a supervisor when an employee unreasonably refuses to avail herself of the employer's complaint procedure. An even more fundamental change has been on the rise of alternative dispute resolution procedures intended to take the place of lawsuits. Agreements requiring employees to use arbitration rather than the courts as a means for resolving employment law claims are generally enforceable. The Supreme Court decided that arbitration agreements between employers and employees are covered under the Federal Arbitration Act and thus generally enforceable. The FAA, enacted by Congress in 1925, requires courts to enforce most written arbitration agreements. The court's evident enthusiasm for arbitration does not mean that arbitration agreements will always be enforced. Even with a signed arbitration agreement in hand, an employer is still subject to administrative proceedings and possibly a lawsuit brought on by half of an employee by an administrative agency. Arbitration provisions in collective bargaining agreements will not bar litigation over violations of individuals' legal rights unless the contract language clearly and unmistakably requires arbitration of both legal and contractual dispute. To meet this standard, a collective bargaining agreement must, at the very least, identify the specific statutes the agreement purports to incorporate or include an arbitration clause that specifically refers to statutory claims. Fundamentally, arbitration agreements are contracts. Courts decline to enforce contracts when fraud is involved, the contract was entered into under extreme duress, or the contract is unconscionable. Contracts are unconscionable when the contexts of the agreement unreasonably favor the more powerful party. Arbitration agreements have sometimes not been enforced by the courts on the grounds that they are unconscionable. Some courts may also inquire into the education and legal sophistication of the employee and whether details of the agreement were adequately explained or hidden away amidst copious fine print. The question of enforceability most often turns on the contents of these agreements. One area of particular concern is the procedure for selecting an arbitrator. An essential requirement for a fair arbitration is neutrality. Agreements that give the employer effective control over who can arbitrate a case or require the use of arbitrators with business ties to the employer are unlikely to be enforced. Limitation periods for filing arbitration claims that are shorter than those that would apply to court proceedings have sometimes, but not always, been deemed unconscionable. However, courts also recognize that the relative informality, rapid resolution, and lower cost of arbitration are precisely what makes it unattractive and therefore do not require the arbitrators monitor the proceedings and remedies of litigation. Under the FAA, arbitration agreements are not invalid simply because they contain language disallowing class-wide arbitration, even in cases where claims by individual plaintiffs would be prohibitively expensive. Nevertheless, it is currently an open question whether, despite being permissible under the FAA, prohibiting employees from banding together to bring arbitration cases violates the National Labor Relations Act. The NLRA broadly protects collective action by employees. This includes the right to unionize, but it might also include participating in class-wide arbitration. If an employee takes legal action against his employer and is successful, what does he get for the trouble? Remedies available in employment cases include attorney's fees, court orders, back pay, reinstatement, hiring, liquidated damages, compensatory damages, and punitive damages. Not all remedies are available for every type of legal claim, nor are all the remedies for which a successful plaintiff is eligible necessarily rewarded by the courts. Under the National Labor Relations Act, for example, employees are eligible for make-whole remedies, including reinstatement and back pay, but not compensatory or punitive damages. The awarding of punitive damages is of particular concern to employers. Yet, the threat of punitive damages plays an important role in ensuring that employers take their legal responsibilities seriously. To keep the issue of damages in perspective, remember that the vast majority of cases never go to trial, and that headline-grabbing, multi-figure awards, including punitive damages, are rare exceptions rather than the rule. Even when plaintiffs prevail at trial, judges routinely slash jury awards by half or more. Punitive damages may be capped. The ceiling on combined compensatory and punitive damages in discrimination cases brought under Title VII of the Civil Rights Act is $300,000. While the costs to employers of employment law claims are sometimes overstated, they are still well worth avoiding. Knowledge of employment law will help you recognize, analyze, and deal effectively with the many issues that you're likely to encounter. It should also enable you to put in place sound policies and practices that prevent many legal problems from arising in the first place. Managers need to know about employment law so they can institute policies that prevent violations, recognize situations that raise legal concerns, and know when to seek legal advice. Most often, lawyers get involved after the fact when legally indivisible actions have already been taken and organizations are in damage control mode. Managers, in particular human resource managers, have a central role in legal compliance and need to have a solid grasp of employment law. Non-compliance with the law is not an option, but choices remain as to how to go about complying with the law. How should issues on which the law is currently unclear be handled? How proactive should employers be in seeking to avoid legal problems? How far should employers go in settling claims rather than litigating them? These choices can be seen as defining an employer's legal compliance strategy.